I still wake up some nights hearing the echo of a gavel in a silent courtroom. They call me Judge Jury. I'm 83 years old and I spent 40 years defending the law from the bench. There is one ruling, perfectly legal in every way, that still keeps me awake at night. For most of my career, I believed the law was the closest thing we had to fairness. It was written down, debated, revised, and refined. It did not shift with emotion. It did not bend with sympathy. I saw my role as simple, though never easy. Apply it faithfully, protect its integrity, leave my personal feelings outside the courtroom doors.
That belief made me steady. It made me respected. It also made me certain. The case that changed me came late in my career. The defendant was 19 years old, no prior record, charged with armed robbery, a small neighborhood convenience store. No one physically injured, but a firearm had been present. Under our state statute, that detail alone triggered a mandatory minimum sentence of 15 years. Mandatory minimums are designed to eliminate inconsistency. They remove discretion from judges and promise equal treatment under the law. I had supported them publicly for years. I believed they protected the system from bias. The evidence against the young man was clear: surveillance footage, witness identification, his own admission that he had been there. The jury found him guilty after several hours of deliberation. The conviction was solid. There were no procedural errors, no grounds for dismissal. Legally, it was one of the cleanest cases I had seen. At sentencing, he stood in front of me wearing a borrowed suit jacket that didn't quite fit. He spoke softly but clearly. He said he had made a reckless decision trying to help his family pay overdue bills. He did not deny what he had done. He did not blame anyone else. He asked whether there was any way to accept responsibility without losing 15 years of his life. I already knew the answer. The statute required 15 years, not up to 15, not a range, exactly 15. My authority did not extend beyond confirming that the law applied, and it did. When I pronounced the sentence, my voice was steady. I explained that the court was bound by legislative mandate. I spoke about deterrence, about uniformity, about the rule of law. Every word was accurate. Every step was proper. His mother was seated behind him. She did not shout or protest. She simply lowered her head into her hands. I remember thinking that I had just changed the direction of 3 lives in less than 5 minutes. That night, I reviewed the file again in my study at home. I have always believed that doubt must be examined, not avoided. I searched for any legal pathway I might have missed. There was none. The ruling was correct. Appeals were later filed and denied. The sentence stood. And yet, something in me had shifted. For decades, I had equated justice with adherence. Follow the law precisely, and justice will follow naturally. But that case forced me to confront a more uncomfortable question. What happens when the law and our sense of fairness do not fully align? I did not suddenly become reckless from the bench. I did not disregard statutes or rewrite rules. That would have been irresponsible. But I began to understand that judicial power, even when constrained, carries moral weight beyond technical compliance. In later cases where discretion existed, I used it more thoughtfully. I listened longer during sentencing. I paid closer attention to context, to history, to the human story behind the charge. I realized that fairness is not only about consistency, it is also about proportionality and purpose. The law is a tool. It protects society. It creates boundaries. It establishes consequences. But it is administered by human beings, and human beings must never forget the impact of those consequences. A few years after I retired, sentencing reforms were enacted in our state. Mandatory minimums were reduced in certain nonviolent cases. I later learned that the young man's sentence had been shortened. He served 12 years instead of 15. I do not know whether those 3 years made the difference between despair and redemption. I only know that I had once believed the system needed no reconsideration. At 83, I no longer wear the robe. I no longer sit above the courtroom floor, but I still think about responsibility. I think about how easy it is to hide behind structure and say, I was only following the law. Sometimes that is exactly what integrity requires. Other times, it demands that we question whether the structure itself serves its intended purpose. The ruling was legally flawless. I would pass it again under the same statute because that was my duty. But I no longer confuse legal perfection with moral peace.
They called me judge jury because I was decisive. What I have learned long after stepping down is that true wisdom is not the absence of doubt. It is a willingness to live with it, to let it refine you, and to carry the weight of your decisions long after the courtroom empties.